Okay, good evening, everyone. I trust you people can all hear me. Welcome to today's session. It's another class or another time, week five of the Gypsy Mentorship and Internship Program, and we are back here again for our patent drafting course. Our topic for today is filing patent application. My name is Dennis Williams, and I'll be your moderator for today. You are all once again welcome to the session. Right, we'll be starting as soon as we can. Our men are not yet here with us, but I'm sure they'll be joining us shortly. But before we have our mentors join in, right, I'll just be taking some announcements. So, um, right down to the announcements. Um, registration for registration for Q1 for the next quarter, right, is currently ongoing. So please, do well to register. You can do well to reg- you can do well to register for another course if you would like. Our courses available for mentorship are artificial intelligence, patent drafting, health tech and law, intellectual property, entertainment business and law, the energy industry, the fintech industry, and just a host of other courses. Alternative dispute resolution. We just have those available, right? And if you would like to also refer a friend for our program, we would really appreciate. You can always reach out to me, and I'll do well to send you the registration link. And just to remind our mentees that if you still haven't paid for the course, please do well to ensure to do that before the end of the coming week, as we'll soon be rounding up with the program in itself. Subsequently, we'll be sending announcements to the group about the schedules for week six and the particular tax for the week. Actually, in week six, we'll be having three classes or three sessions rather. Those three sessions will be on the same day on Saturday, 11 a.m. WAT, 2 p.m. WAT, and 5 p.m. WAT, all combined classes for all our mentees cut across all through the mentorship program. So we'll be having a combined class in that particular order come Saturday. The task for the week will be sent to the group later this evening or early tomorrow morning. So please do well to always pay attention to further details that may be sent to the group. So still on to introducing our mentors. Not to waste any time with the introduction, considering that they have been with us in and through the entire frame of the quarter, starting from week one down to this current week. Our first mentor for today is Mr. Rakesh Sharma. Mr. Rakesh is having a thorough and multifaceted career spanning nearly a decade in analytics, drafting, and prosecution for US and EP jurisdiction. He works very closely with various engineering teams and supported their portfolios from ideas incubation to innovation management. Mr. Rakesh has excellent understanding of patent law, claims interpretation, and drafting skill. As a seasoned professional, he readily engaged with various end-to-end IP services at different levels and provides intelligent IP solution. He emphasizes more on promoting innovation for a better world. He loves drafting patent claims, keeping all the infringement perspective in mind. Furthermore, he is strong bent of mind towards IP automation and has sound knowledge on various IP tools and techniques that can be used for either improving quality of IP or increasing the overall productivity. He is also an excellent mentor and possesses all the leadership quality required for a professional required for a successful IP professional. So that's the profile for Mr. Rakesh. We look forward to having him in session. We are trying to keep in contact with our mentors to see that they are able to join us in the shortest possible time. Um, our next mentor for today that we're expecting on this particular call is Miss Amusa Shukurat Mudupeola. Shukurat is a seasoned intellectual property consultant, analyst, and educator with public sector experience. She holds a master's degree in intellectual property from the prestigious Africa University Zimbabwe in collaboration with WIPO and the Japan government. Shukrat is an alumni of the World Intellectual Property Organization, a member of WIPO International Network for IP Education, as well as training facilitators at the NETS Innovation Hub. She was a member of the planning committee for WIPO National IP Essay Competition 2023 and resource person at the National Intellectual Property Conference NIPC. Shukrat is an accredited agent at the Intellectual Property offices in Nigeria and the pioneer of the Intangible Nuggets, an educational platform which is responsible for fostering, amongst other things, intellectual property advocacy, awareness, and education. So that's the profile for Miss Amosa Shukurat, also not yet here with us. Well, I'm very confident she'll be joining us shortly. So I will kindly ask that we bear patience while we try to see how best we can get through to our mentors for them to join in into the session. But as we wait, right, um, I want to just generally have a basic line interaction, baseline interaction with our mentees to just to have feedback or insights in that sense as to how the program or the mentorship program has been so far for you in your own words, considering everything that you've had to learn, right, coming from week one down to week five. So, if it's possible, can we just have maybe take turns, right, while we wait for the session to officially start? Just take turns to just discuss about the mentorship program in a whole, what have been some of the experience you've had and the well, let's say feedbacks in those sense. What are your feedbacks on the program and how do you generally in turn just perceive the mentorship program? So just starting from the top of the list, um, here on the screen. I think I'll be starting with Nigos. So Nigos, please, if it's possible, can you kindly turn on your mic, right, or unmute yourself so that we can just hear from you. What has been the experience so far with the mentorship program? How has it been for you? Nogos, if it's possible, I would like to hear from you, and then we can just move on to the other mentees while we wait for our mentors to join in. Okay, Nogos, please, are you with us?
Yes, can you hear me?
Yes, I can hear you loud and clear.
Well, the mentorship has been good so far, but with regards to the time, it's very late, and I it would be nice if it could be at the daytime because at the night time, most of us are sleepy, and in addition, another comment would be. Uh, uh, Another comment about the mentorship would be it's nice, but with regards to the time, if we could have some adjustment, it would be nice. And that is my comment.
Okay, thank you very much, Nogos, for that. As regards the time, um, on Sundays, this particular time frame for the mentorship is set because from between the hours of 4 to 6 p.m. West African time, we do normally have a session on health tech and law. So health tech and law is the session that precedes this particular session. So it's actually a bit of a precarious situation for us as well, trying to fit the particular time, considering that majority of our mentees also on this call are not based in Nigeria, right? So we tried as much as possible to, in our own best way, to make sure that we accommodate, also considering the other courses that we are taking. So this is for us the best possible time. But like I said, in the next session, right, this is the fifth week, and officially we'll be ending with patent drafting in this week. The other subsequent classes or sessions we'll be having will be combined sessions. So in those sessions, the timing will be much earlier. Like I said, 11 a.m. WAT, 2 p.m. WAT, and 5 p.m. WAT. So I guess that time frame will be better set in that sense from you. Thank you, Ms. Shukurat, for joining. We are just having a little interaction with the mentees as regards the program so far. And I would just like to hear from two of them, then we'll start off officially with the session. So, Zinatu, if that's possible, I can see you are with us. Please, can you unmute yourself and just tell us how the mentorship program has been for you, and is there any feedback you would like to give? Zinatu, are you with us? Okay, I can see you're unmuted, but it seems there's no sound from your end.
Okay. Hello, good evening.
Hello, your network seems to be a
Hello.
little. Hello, Zinatu, can you hear me?
Yes, I can hear you.
All right, so please, we'll just like to hear from you. How has the mentorship program been for you so far? And do you just generally have any feedback for us?
Okay. So overall, actually, not really that rich for me my time because I've had to be off classes because of my network. Like that. Like, like, okay,
Okay, your network seems to be a little bad, right? So we can't really hear you clearly, but we'll still like to hear from you. If it's possible, can you just kindly drop your comments in the chat box so that I can just probably read it um, once that is in the comment section. So thank you. Sorry, not to steal,
sure.
right? Your network is kind of poor. So
Right.
favor, please, if you can, just your general thoughts about the mentorship program and just maybe a feedback or two from you. Thank you, Mr. Rakesh, for joining. You're welcome, sir.
Thanks, welcome.
So, favor, are you with us?
Okay, yes, Mr. Dennis, I'm with you guys. Can you hear me?
Yes, loud and clear.
Okay, so the program has really been helpful. Personally, for me, it's really boosted my level of dedication to tax, and because I must admit I have a great way of not being too dedicated to tax, but it's really helped me. And as to content and substance, it's really been impactful. I've learned a great deal from it. But I don't know. I think it's more like a suggestion because maybe I was misinformed. I felt like when we signed up, the program said something about assigning mentors individually. So I had the thought that it was going to be a mentor to a person, but looking at the scope of other I don't know, because we are relatively small here in the patent drafting, but I think some other classes are quite large. Maybe that's why it's impossible to assign a mentor to a person, but it would be fine if maybe it's like a mentor to individual, maybe a group of 3, 4 persons. That would go a long way too.
All right. Thank you so much, Favor, for that comment and your suggestion. So about what you have said about the mentor mentee 1%, I think we addressed that in the onboarding session we had at the initial start of the program. How that how that we are actually working on a separate private mentorship um, masterclass, in that sense, where we can pair up mentees with mentors, but those classes will be paid for. But we are actually working on that. They are in their that is in the development stage, so we are looking at that, right, as one of the ways that we seek to further expand the mentorship program. But also we many times make sure that, or advise that, you reach out to the mentors personally, you follow them on LinkedIn, try to build personal connections with them, considering that you are a mentee, right? We are very sure that our mentors will always do well to respond to you if you have questions or you need further guidance in any aspects or area that you may be unclear of or unsure of. So we actually give that opportunity to our mentees. Also, with your postings, you can tag when you write articles on your postings after sessions. You are supposed to tag the mentors, and then mentors as will in turn reply and respond to some of the things you've written, right? So we advise also that, as much as is within your power, right, that you try to connect with our mentors on LinkedIn. Just try as much as possible. You can reach out to them at I think at will, and I'm sure our mentors will be in the position to help as best as they can. So thank you to our mentees that have been on call and have given their feedback. Now we'll just be heading straight into the program for today. Thank you so much, Ms. Shukurat and Mr. Rakesh, for joining in. Okay, not to waste any time, I think we know the drill. We'll have presentation first, and then we'll have our talk and our discourse from our mentors as alongside their feedback on the presentation. So, the presenter for the week, please kindly come up, make your presentation 10 minutes so that our mentors can give feedback to your presentation and also give us their discourse for this particular class. We would like to, okay, who is the group presenter for the week? Please go ahead and start the presentation.
Okay, so I'm the presenter for the week, and let me share my screen. But before I share my screen, so I think the presentation that was probably submitted, we later discovered it was incomplete as of this morning. So I will be sharing a presentation quite different from what was submitted, because it has the comprehensive work of everybody. The one that was submitted, it's not complete.
All right, thank you for that clarification. Please kindly do well to send the complete version to me after this session. We'll still try to get it across to the mentors for them to still review. So thank you, Favor, for that clarification. Go ahead and share your screen.
Okay. Okay, can you see my screen?
Yes, we can.
Okay, so the topic we'll be addressing is optimizing patent application strategies, a comprehensive analysis of filing processes, duration and priority considerations in provisional, local, regional, and international context. Okay, so the next slide. Provisional patent filing processes. So they are basically five we summarized it to 6 processes. Now, the first step in the provisional patent filing processes is, first you have the innovation. It's must fall within the patentable subject matter. That is as regards the processes, machines, articles of manufacture. Now, the next one is the preparation of preparing the application. When we go to the third and the fourth, you have to you create your cover sheets. Also, in preparing the application, sorry, you must include like a detailed description of the invention, the purpose of the invention, its functionality, and any other unique features that it could contain. You also include drawings, diagrams, whatever element you think would give a comprehensive description of your invention. Any relevant data, you have to include it. Now, a cover sheet should contain basic information regarding your application. So it must contain like the title of the invention, the name of the inventor, and any of the contact information of the inventor. Then the next thing is drafting of the specification document. Now, in drafting the specification document, you must fully describe the invention. That you must include if there are components to your invention, the method of operation, any potential application or unique application to your invention, you must state it. And like we said also, you can back this up with images, graphics. Then in organizing a specification document, it's not exactly a mandatory requirement, but it would best you classify it to maybe background, summary, description, conclusion. This would put a form of organization to your specification document, and it will be easy to identify specific information. Then, of course, the filing of the application. Now you have to, after deciding the application, the filing system you want to use, you have to file your application. And the next thing is post-filing considerations. Now, post-filing, when, for instance, now in a provisional patent application, there you'll be assigned the patent pending status for maybe the specified date. Now, under the USPTO, it's probably 12 months. So you'll be given like the duration, and within that period, you can refine your invention, you can conduct further tests, or you can equally prepare a provisional patent application if you wish to pursue patent protection. Now, requirements for patent application. It's just like a submission of what we had said earlier. Your invention must fall within the patentable subject matter. Now, the specification document must be concise. It must be comprehensive. It must completely describe your invention, such that if somebody else wants to replicate your invention, the person can include an executed oath or declaration from one of the inventors stating that, okay, that they genuinely honestly believe that they are the original inventors of this invention. And then the last but not the least is the payment of the appropriate filing fees. Now, what are the advantages of filing a provisional patent application? Now, the first thing is that the patent pending status that is usually assigned to a provisional application, it can be utilized to attract investors and also generate substantial commercial interest in the market. Next, it establishes a priority over subsequent applications. So once there's the early filing date, creates a priority over any other application that might come after your application. Then, of course, provisional patent application is cost effective and is usually advised for persons in early stage invention. That way you don't spend a lot of money in carrying out a application, but at the same time you can also put up a form of protection over your invention. Then the next one is confidentiality and protection during testing period. Like we said, it creates like a form of it establishes like a protection over your invention, and it gives you the room to test for further testing of your invention. Then flexibility. Now, a provisional patent application does not necessarily require a formal declaration from the inventors. Now, we try to look at patent filing in different jurisdictions, and we are looking at the East Africa. Now, the two countries we singled out is Kenya and Tanzania. Now, filing patent generally, just like in other jurisdictions. Sorry, can you hear me? Can you hear me? Hey, nobody's responding. Can you hear me?
We can. Yes, we can. We can, Favor.
Okay.
Yes.
All right. So as I was saying, just like in other jurisdictions, patent filing in East Africa involves like a lot of going through like certain specific regulations and procedures which the country has set forth through their respective patent offices. Now, in Kenya, the patent system is governed by the Industrial Property Act. Now, the government agency responsible for administering patents is the Kenyan Industrial Property Institute. If you come to Tanzania, the regulation in charge of patents is the Industrial Property Act also, and the government agency, BRILA. Even though that the processes of patent application may vary in these jurisdictions, they tend to have like a similar thing. They tend to have like similarities, which is like the steps we already mentioned above. But I will try to mention like a few things out of it. Now, to file a patent in Kenya, the investors must follow the steps that has been outlined by the Kenyan Industrial Property Institute. Now, one of it is the Priority Act search. Now, once the Priority Act search is like the first step to determine that your invention is novel and not already disclosed in existing patent or publication. This will also help determine the patentability of your invention. Now, once the Priority Act search is completed, now inventors can proceed to prepare the patent application, like which must be contain like a detailed description of the invention. It must define the scope of it must contain the claims defining the scope of protection sought. It must also contain like any necessary diagram or drawings that would help identify the invention. Now, after preparing the patent application, you now submit it to the Kenyan Industrial Property Institution. Once you submit it alongside your filing fees. That's, you must pay your required filing fee. Then once this is done, a formal examination will be conducted. And if after the examination is conducted, then your invention is found qualified, your patent will be granted to you. Now, in Tanzania, it is the same thing. It's exactly the same thing. The only difference is the government agencies that the government agency that you'll be filing your application to. So generally, both the Tanzanian and the Kenyan jurisdiction, they have tried to simplify things for persons seeking to submit application by creating like an online an online platform wherein inventors can file their patents. Now, this has enhanced like accessibility to IP protection, and it has also helped to fast track and speed up patent applications. Now, also the both government has taken necessary steps to enhance like public awareness of IP rights and protect and provide support services to inventors seeking to protect their invention. Now we go to regional patent filing system. Now, patent filing, like we've said, you can decide to file your patent. We'll get there. You can decide to file your patent using locally just in your country, or you can subscribe to like a body that governs like countries within specific region. So that's what we are looking at, regional patent filing system. Now, what features do these regional patent filing systems have in common? Now, they allow single application for multiple jurisdictions. So it means one application covers different countries. Then it uses a unified examination standard. For instance, now if you're going taking the European patent convention, the application and the examination standard is the same regardless of the country, so long as it's part of the designated country. Now there is a centralized publication. There's no need for you to start publicizing differently in different countries. Then it identifies and it allows the countries under it fall within an identifiable scope. So once you hear European patent convention, you automatically knows, okay, this like applies to European countries. You hear African regional ARIPO. When you hear ARIPO, you know that this applies to African countries. So just like that. Then requirements for validation and translation. Everything is one and the same. The requirement for validation, the requirement for translation, it doesn't vary from country A to country B. It's just one umbrella. Then the unified renewal and maintenance structure is the same thing. Now, what are the examples of regional patent systems? Now, we have the European Patent Convention, we have the Patent Cooperation Treaty, PCT. This PCT is mostly used in the United States. Then we have the African Regional Intellectual Property Organization, which covers over, I think, 149 African countries or so. I can't really remember the number, but it covers like a large range of African countries. Then you have the Eurasian Patent Organization. This is it covers the Asian. Just 1 minute. It covers the Asian countries. You have the Gulf Cooperation Council Patent Office. You have the Organization of Islamic Cooperation Patent System. You have the ASEAN Patent Examination Corporation, and you have the Benelux Patent System. Now, what is the merit of this regional filing systems? Like we said, it allows easier access to documents based on their relevance to specific geographical areas. So it is easier to retrieve information. Now, is simple and easy to understand. Can you hear me? Can you hear me?
Yes, we can hear you.
Okay.
Yes.
It
Your network is
allows.
great.
Can you hear me now? Can you hear me?
Yes,
Yes.
we
It's
Yes.
better now.
can hear you
Yes,
now.
it's better.
Go
Okay.
ahead. Please, can you?
Okay. Ca- It's it efficiently allows retrieval of documents pertaining to a specific region without having to sift through unrelated materials, and this saves time and effort. Now, it also aids in analyzing trends, patterns, and issues that relate specifically to a particular geographical areas. That this helps in decision making, like when inventors have to decide what patent filing system they want to adopt. So the ability to understand the trends associated with a particular patent system, the patterns, issues relating to that system, it enables them to make decision as to choice of patent system. Now, collaborative access of shared documents within their respective filing system promotes seamless communication and cooperation. Please, 1 minute. Okay, sorry, please. Like I was saying, I said collaborative access of shared documents within their respective filing system. It promotes seamless communication and cooperation, because it's easy to transfer information from one jurisdiction to another, because all of them fall under a particular filing system. Then it helps to ensure compliance with regional regulation and standards by segregating relevant documents for easy monitoring and auditing purposes. Now, lastly, it allows for scalable and adaptable document management solution. Next slide. What are the challenges of patent filing system? Now, it could lead to duplication of efforts. The fact that different filing system has to be maintained for each region could lead to duplication of efforts. Now, there may be inconsistency as to how these documents are categorized or filed, and this could end up in causing confusion, and retrieval of documents may not be done correctly. Then there is the communication barrier. Sometimes the language used may not be the adopted language. Unified language may not be the language that is common in a particular jurisdiction. Now, managing multiple regional filing system, it increases the risk of data breach and unauthorized access. Although we believe that with the right infrastructure, that this risk could be mitigated against. And then the last but not the least is difficulty in conducting comprehensive analysis or comparison across region when the data is separated into different filing systems. It can limit the organization's ability to identify overreaching trends or issues. Now, let's look at international patent filing strategies. There are basically two patent filing strategy. You could use the patent cooperation treaty route, or you could file directly in your jurisdiction. That's the national route. Now, what key questions should a person ask when filing patents? The first question is, where should one apply? Now, if you've determined what route you want to take in filing your patent, the next thing for you to ask is, where do I file my patent? What is the right office to file my patent? For instance, now, if you're in the US, of course, you know that it has to be in the US PTO that you would file your patent. Same goes for persons, that is if you're adopting the national route. If you decide to go through the sorry, that's if you're adopting the PCT route. Just a minute. Okay, sorry. The next question is, when should an application be filed? You have to determine at what stage of your invention that you should file an application. Then the next is, okay, haven't identified when your application should be filed. How should the filing be done? What are the procedures? What are the requirements? What are the documentary requirements? What are the processes involved? Now, should the application take the international route, that's the PCT, or should it take like the national route? Now, when you've decided which of the routes you're taking, you now have to find out what is the cost of the filing. Then the next thing is, what are your commercialization plans? Now, it's your what are your commercialization plans? What is the desired market? What are the timeline considerations? You have to put all this, factor all this before you can go ahead and file your patent application. Now, the key aspects of patent filing, areas for consideration in patent filing is the prioritization of markets. You have to identify what key markets where the protection is essential. For instance, now you have to understand what is the market size. Now, what are the potential infringement risks, and does it align with your business objectives? You have to determine all these things. Then the next is timing. Now, what is the maximum or minimum time for filing your patent application? Is there like a traditional timeline, or even when there's a traditional timeline, are they accelerated timelines, accelerated methods for you to speed up their application process? Now, for instance, now in timing, it might involve like filing an initial application, maybe in your home country, maybe through your in the US, maybe through your for US through the USPTO, or if you are in the European region through the European Patent Office. In either case, before if it involves that, it means that you have to file application in your home country before you can now expand to other jurisdiction. Then there's the budgetary consideration. This is like one of the most important things. You have to consider, oh, is the budget available going to cover the cost of your application? Then when you consider this, you now also look out, you prioritize the countries based on their strategic importance and the associated costs. Now, the regional filing patent system. Now, you consider what regional patent filing system that is applicable to you, and which one, most importantly, is cost effective, is a cost effective alternative for you in relation to the individual national application. Then you have the national filing strategy. Now, you have to also determine whether to file directly in your country, like we said, especially where your country has like very crucial IP laws, that the potential the protection level is high, or you can decide to take the national route. Although sometimes it has been argued that this national route might not provide like adequate coverage for you. The international route, sorry, may not provide adequate coverage for you. Now you have to customize your application. Now your application must meet the specific requirements of each jurisdiction. It must comply with their patent laws. It must be done in the required language, and it must fall under the it must be in accordance to the examination procedure. Now, you also look at what is the enforcement consideration. Now, evaluate the effectiveness of enforcing patents in the different jurisdictions. Now, you must identify like what are the legal remedies available for me. Should there be a case of breach, or if there's a case of breach? Now, what is the strength of the IP enforcement mechanisms? Now, what is the risk of an infringement? If there's an infringement of my patent rights, what is the scope of the risk? Now, the last second to the last, the portfolio management level. You must develop a long-term strategy for managing an international patent portfolio, like periodic review, maintenance, and potential adjustments. And this potential adjustment must be done based on the market dynamics and your business priorities, of course. Then of course, you have to seek professional advice. As an inventor, yes, you can, thank God for the internet, you can read up, but it's always advisable to seek the help of IP professionals, people who have the expertise in international filings, or whatever is the case, patent attorneys in your region, in your jurisdiction. These people will help to guide you on the most effective strategy to adopt for protecting your invention. Now, just a quick comparison of the patent treaty route and the national route. That's, for us, PCT is like the international route and then the national route. Now, there is the case of the PCT has like centralized application process. Now, the decision, it has like an extended decision time of 30 months. Sorry, this is an error. It's not 30 days, it should be 30 months. 30 months from the priority date to enable you determine what country or region you want to pursue your patent protection. And this extended time is actually very advantageous for to an inventor. It will enable the inventor evaluate the commercial potential of the target jurisdiction, seek the commercial potential. To also enable the inventor to seek investments and, of course, money funds. And it will also enable you to conduct market research. Now, cost efficiency. As regards cost efficiency, the PCT is relatively lower when compared to like filings in a couple of countries. So the overall expenses, it may increase during the national or regional phase entry. Now it uses a unified search and examination standard. Not listed here, I think we also have the advantage of flexibility and uniformity. Now, the PCT offers flexibility in choosing countries for your national entry, national phase entry, and it ensures that your application format and the procedural requirement is uniform across the member countries. But when you look at the national route, the advantage of the national route is, of course, it provides immediate protection. So once you file in your country, it allows you to like have protection in your jurisdiction without having the need for international coordination or other additional formalities. Then tailored strategy. Direct filing enables applicants to tailor their patent strategy according to like the target market need. It will also help you to tailor your filing in accordance to your commercialization plan and the regulatory requirements of your country. Now, the grant of patents under the national route, it's quicker because you apply to your national patent office, and the examination process is faster, and it will result in early enforceable rights. Sorry. Now, cost consideration. Although that the initial cost may be higher when you compare it to the PCT route, direct filing can be cost effective for applicants when you're targeting like a select number of countries. This is because there's like a clear understanding of their of the target market. Now, localization. It's easy to adapt your patent application to the local laws of the country and even the language requirements. And this could enhance your chances of a grant of patent. Now, the next slide. What are the steps in filing patents? Okay, this slide is a mix-up. It's applicable to filing of patents in East Africa. When we're talking about Kenya and Tanzania, and I think I already explained it, sort of. I already touched on all of it. Prior access, preparation of patent application, submission of filing of application and payment of your requisite fee, patent examination by patent administration agency, grant of patent. Now, the next thing is duration of patent application. We try to look at the different duration of patent administration in different countries. We looked at, when we're deciding this duration, we looked at US, China, Europe, Japan, South Africa, Nigeria, and Egypt. Now, we try to look at this duration for countries that allow accelerated or expedited examination as against countries as against the country's traditional examination.
Hello, Favor. Please, can you begin to round up with the presentation?
Okay, I'm almost done. This is like the second to the last slide. Duration of patents, just a minute. So in the United States of America, for accelerated and expedited examination, it's like 6 to 12 months, whereas their traditional examination period is 24 to 36 months. In China is 1 to 2 years, whereas traditionally it's like 2 to 4 years. In Europe, it's 1 to 2 years, whereas the traditional examination period is 3 to 5 years. Now, in Japan, it's 2 to 3 years. Traditionally, it could extend for as long as possible. There's not like a definite time as to it. Now, in South Africa, Nigeria, and Egypt, would say that there's really no provision expressly for like accelerated or expedited examination of a patent application. But the traditional timeline for South Africa is 3 to 5 years. In Nigeria, is 4 to 6 years. In Egypt, is 4 to 6 years too. Now, what are the factors that affect the duration of patent application. You have backlog of patent application. This could be caused by understaffing, limited resources for the agency, maybe administrative challenge, issue of bureaucracy, and a whole lot of procedural issues. You have examiner workload. Now, when they are understaffed, it's possible that there will be like excess workload on the examiner. Now, the procedural requirements suffers challenges such as language requirement, language challenges, documentation standards, and formalities. Then we also have, last but not the least, inadequate infrastructure and resources. Now, we try to provide a solution to these issues. We believe that when these government agencies or these offices employ expert staff, it would solve the issue of it will employ expert and experienced staff. It will solve the issues of examiner workload, understaffing. Then provision and acquisition of required resources will address the issue of limited resources that result in backlog of patent application. Then the application procedure must be well defined and clear. And then to solve the issue of language barrier, they should try to invest in language professionals to enable them navigate the language barrier issue. Now we'll look at priority dates and periods. Now, what is a priority date? Now, the priority date of an invention is the earliest filing period within the family of a patent application. Now, what is the filing date of a patent application? Now, when there is a sole application, the priority date would be the filing date of the sole application if it is just one patent application that is involved. But in a case of several several related patent application, now the priority date will be the date of the earliest patent filing that was first disclosed in the invention. Now, the priority application date refers to the initial the priority application refers to the initial patent file. Now, what is the significance of priority date? Now, priority date, it affects the invention's ability to be patented. Now, it also established like a limitation, a boundary for previous acts that should not be crossed. It limits the scope for a previous act. Now, the new features that can be introduced due to later priority dates would depend on when they were initially disclosed in a patent filing. Now, another importance of priority date is that it limits the number of prior acts references that can be referenced against claims of novelty. We will try to present like a scenario. Now, if there was a provisional application on the 10th of June 2016 and it disclosed, let's say, features A and B of an invention, and then they now had like in June 9th, 2017, the following year, through a non-provincial filing, it introduced, let's say, feature C. And then still under that same year where there was a provincial filing, under the CIP, it was an application was filed that now introduced feature D. Now, the priority dates will read as follows. Now, for features A and B, the priority date will be June 10th, 2016. Now, but for feature C, which was introduced under the non-provincial application done in June 19, the priority date will June 19, 2017. The priority date will be June 9th, 2017. Now, for feature D, that was introduced using the a CIP application, the priority date will be October 20, 2017. Now, this is how we determine priority dates in an application. Now, what are the types of patent priority dates? From the scenario we explained earlier, you would have figured it out. There's the filing date of the provincial application. There's the filing date for the non-provincial application, and there's filing date in the case of a foreign application. Now, how do you claim priority? First, you have to submit your patent application. And this your patent application must detail the invention, detail the usage of the invention, and this is known as the enablement requirement. Now, the next thing is you can submit more. They can submit more patent applications. These ones will be categorized. It will be like a continuation patent application, maybe a PCT application, or even national application. Now, the subsequent application must would trace their priority to the first application submitted. And how do you do it? You have to reference the previously filed patent application. Now, when you're filing a subsequent application, you must endeavor that to submit it while the initial application is still pending. Then of course, you have to enlist the help of a patent attorney to guide you through it. Now, there could be a case of multiple priority. Now, multiple priority happens when two or even more applications, they are related in such a way that one can say that they constitute like a single invention. But multiple priorities are actually subject to the fundamental priority rule, which means that an earlier invention must support the entire specification for which the application may be filed. Now, the earliest filing date must be the earlier filing date disclosed would end up being the priority date. Now, patent filing date versus priority date. The patent filing date of an application is the date it was submitted to the patent office, whereas the priority date is the date that is used to determine whether an invention is original or obvious in comparison to any prior act. Now, the application filing date, it may not in some cases match the priority date, but it can match the priority date. It can match the date on the parent application if it claims priority to an earlier parent application. Now, the filing date of a patent application is often the same as the priority date if it's like original, or it could be a non-provisional patent application, and not just like a continuation application or an application that has been filed in another nation. When a patent application may claim priority to an earlier application? Simple. Where the continuation applications, they have like typically equal dates. The domestic applications are based on a foreign or international filing. That's assuming it was first submitted internationally and then subsequently filed locally. And then the patent filing is based on a provisional patent application. Now, priority dates can be maintained or lost. Now, when can a priority date be lost? A priority date is lost when there is a failure to convert a provisional application to a non-provisional application within the specified deadline. So once there is failure to convert it, this will result in like the loss of a priority date. Now, however, hope should not be lost. You can refile the provisional application that will now necessitate a later priority date. And this could increase the likelihood that a further priority act will be used against the applicants. Now, there are important deadlines to note when it comes to priority. There's the 12 months deadline. This is in line when you're considering the PCT. Now, you must submit an application for the same invention in a different nation within a year of submitting your initial application if you want your application to be given priority in that nation. Now, there is the 16 months deadline. And the 16 months deadline is that you have 16 months from the priority date or the date you filed your first application to request that priority be based on an earlier application. Now, if maybe this 60 months is like a later date, you can request for priority within 4 months of the date which you submitted your new application. Thank you. Thank you, everybody. Thank you for listening.
Thank you very much, Favor, for that very detailed presentation that you made to the group. We are happy that you were able to put in the work that research done. Mr. Rakesh had to leave because of the circumstances around his timing. He couldn't say, but he promised slides. We'll do that once his slides. We'll share the slides with the mentees once he sends them over to us. So, please, we'll just like to hear from our overview of the topic and feedback from the mentees. We already have questions from from Nugus. I think probably he had to go, so he just sent his questions early. I would just like to hear from you, your overview on the topic and just feedback presentation. Ma. Ms. Shukurat, are you with us, ma?
Yes, I'm with you. So, Dennis, yes, I'm with you. I think Mr. Rakesh left. So far so good.
Yes, it's not
The presentation was good. However, it was more like you were reading the material. You were not speaking to the material, because if like I doubt if you'll be able to present or say something without that material. So it was as if, yes, you've done the work, but you didn't really familiarize yourself with these processes. Okay, it's more like a paperwork than a presentation. Do you understand? But overall, it was good. Another thing I noticed, like I said last week, is not how would I say it? It's too paperwork. There's no practicality. There's no example that will carry people along on, okay, this is how to file, or this is the chart of filing. When you file in your local office, it takes 12 months. When you want to go through PCT, it takes additional 18 months, the 30th month, then you enter the national phases. You see, there are all these explanations that you get online, but you were focused on the book aspect, right? So because there's the book aspect and there's the practicability, so you should be able to like practicalize it. And I realized that from what you were saying, you were kind of mixing them up. So when it comes to the priority dates, grace period, also I'm not sure you mentioned any convention that is backing all of these things up. Okay, so like I said last time, when I talk about intellectual property, there's always a convention backing this thing up. Okay, so if I want to enjoy priority date, I want to enjoy grace period, I want to enjoy national treatment and all, it means I have to be a member of the Paris Convention, because only the member of Paris Convention can actually benefit from what we said about the provisional application, the grace period, and the priority date. Now, if you are not a member of the Paris Convention, you can file, but you won't enjoy priority dates. You won't enjoy grace period. You won't enjoy provisional application, except if the country you are filing in and your own country, you have a bilateral agreement between both countries. So this is the practical aspect like I was looking forward to. You need to be able to see, okay, this thing that we've read, how can we apply it and explain it to a layman? Do you understand? So is the practical aspect is more important. You should be able to like do a presentation, not read the paper. So that is what I'll say about the one for the Paris Convention. Then now when it now comes to the filing itself, well, I think your presentation you mentioned, I don't have this particular presentation, so I really can't remember most of the things you presented. So you mentioned something about cover page. Yes, so there is nothing like a cover page. When you want to file a patent application, there is always a request form. So I think it's the request form you called a cover page. So that request form is what will contain all the applicant's information. You have the applicant information, your name, your address, this, that, so that if eventually someone wants to license or someone wants to buy your patent, they are able to reach you. So it's not called cover page. It's more like a request form. So you fill that request form with all your details. Then the other aspect now comes, that's the structure of application. I think you also mentioned that the way you structure the application doesn't matter. I would like to correct you that it actually matters, because your patent application must have your title, like we said last week, your title, the field of invention, the description. When you talk about description, you talk about the background of the invention, you talk about the summary, you talk about the brief description of the drawing, you talk about the detailed description of the drawing, you talk about the claims and the drawing itself, if there's any drawing. So all these things have to be highlighted that way, so that you don't just jump it. You can't bring claim to the first page. Your claim has to be at the last page. You can't bring your drawing to the first page. So it has to be arranged the way it should be arranged. What else did you talk about? Let me see. I can't actually remember. I think I screenshotted your I think you talked about, I really can't. Okay. You talk about okay, post-filing consideration, then preparing the application. We've talked about that. Now, you mentioned something about provisional application. So, but I think you are not getting the gist about the provisional application. So, provisional application is just like, okay, fine, I'm an inventor. I want to patent my invention. However, I don't have the full details, or I've not yet, that invention is not yet solid. I've not solidified it. I don't have everything on ground yet. But I want to file so that I can maintain that date. So you file the provisional application. Now, when you file a provisional application, you have 12 months from the day you file your provisional application to file a non-provisional application. So you see that non-provisional application is what the patent office is going to examine as to substantive examination or formality, not the provisional application. The provisional application is just like, okay, I'm putting in my application to book in this particular date. It is not your main patent application. What I can do in provisional application is just, okay, I don't want someone to file before me. So you key in that date and file a provisional application. Then 12 months from when you file a provisional application, you want to file your non-provisional application, okay? And you are still going to maintain that date. Do you understand what I'm trying to say? So it is the filing date that really matters, and that is why you're filing a provisional application. So when you file a non-provisional application, you are going to claim the same dates of your provisional application within that 12 months. Now, when you now file your non-provisional application in your own country, and you feel like, I want to extend my business to another country, now, you now look at, when is the possible time for me to file? Then you now look at priority. Do I want to claim priority in another country? If you want to claim priority, it means you have to file in another country between when you filed your non-provisional application, 12 months from that time, to the country you want to file again. You need to file then. I'm doing so, you're going to claim the priority date of that non-provisional application. However, if your country is not a member of the Paris Convention, you can't enjoy all of these things I'm mentioning, except maybe your country has a bilateral agreement or multilateral agreement with another country who is a member of the Paris Convention. So you want to be able to understand all these things and how it works. It's not just the way it looks like you explained it. So you want to know the details. Even grace period is under Paris Convention. However, it's not all countries that gives you grace period. Grace period is okay, fine. The patent says, or the patent law says, we should not disclose our invention. But I want to test the market. I want to see how acceptable this product is in the market. So you go ahead to disclose your invention. Now you have 6 months from when you disclosed your application to file for patent. 6 months, 12 months, depending on the jurisdiction. In Nigeria, it is 6 months. In some other jurisdiction, it might be 12 months, but it won't exceed 12 months. But if you file after that 12 months, then you won't be able to file a patent application for that invention again because you've exceeded the grace period. So you want to understand how these things relate to each other. So now when you want to file an international application, you want to ask yourself, where am I filing? In which country? How do I want to file? Now you want to ask yourself, am I filing nationally? Am I filing in 1 or 2 or 3 countries or 10 countries? Am I filing regionally? Do I want to file internationally? If you want to file using PCT, do you want to claim priority? Do you want to use grace period? Do you want to file a provisional application before you file a non-provisional application? You have to answer that question. If your country is not a member of the Paris Convention, do you want to file nationally? If you are filing nationally, in which country are you filing nationally? Are you sure you've not disclosed your invention before you file? If you've disclosed, if at all you've disclosed, are you sure the country you want to file in have a space for grace period? So you want to show about all of these things. And if you are filing internationally, you are going through the PCT route. The PCT is the Patent Cooperative Treaty. So it gives you it's just like an international, there's not like a worldwide registration. It's just international filing because you file a single application, you pay a single set of fee, you pay a single translation fee, then you designate the countries. Let's assume you want to file your application in 10 countries. Imagine looking for an agent or looking for agents in those 10 countries. Compared to you filing using PCT and you have WIPO doing all the formalities for you. Your own is just to fill in the application, select the countries, pay your fees, and WIPO does the formality check, send it to they do their search, you get your traceability search report, you get the what's it called, International Search Authority to do their search as well. Once it's okay, they send it to the national bodies now. So the PCT or WIPO are not the one that are going to grant your patent. They are still going to send it to the national offices. Okay, it's just that you won't be the one to do all those stress. It's WIPO that is going to help you to send it to those designated countries. And it is now left for those designated countries to say, okay, fine, this one in our country, yes, we'll accept it. This one doesn't meet up with our standard, we'll reject it. Also, you have to note that each law of every jurisdiction is different. For example, in Nigeria, the patent law in Nigeria doesn't assess patent application as to substantive examination. The only thing we do is formality. That is, we only check, do you arrange it well? Is the inventor name there? Is the abstract there? Is this there? Is that there? We won't go ahead to go and search and start looking for prior acts and start looking if it's inventive, because our patent law doesn't do examination as to substantiveness. Okay, we only do as to formality. So you want to know the patent law of the jurisdiction you are in. Do they do as to formality or do they do as to substantiveness? So these are the kind of things you have to bring into the conversation when you're mentioning the South, the Kenya, and the Tanzania. So you want to compare which law, what's the law of Kenya, what's the law of Tanzania? Do they have the same law? Do Kenya have grace period? Do Tanzania have grace period? Do they do substantive examination or formality examination? So most of these things are what you want to put into consideration. So I think we'll take question here because I think we have spent so much time with the first presentation. Yes, so I think I'll stop there. Thank you. I think you are muted. I can't hear you, Dennis.
Okay, thank you very much, Ma. Thank you for helping us run through that and also giving feedback to the presentation and correcting places where you felt like there needs to be correction. sure our mentees are taking all that into consideration. Okay, so down to questions. Down to questions. I saw Nugu's. I think before he left, there were some questions he dropped on the chat box. So we'll be reading Nugu's question as well as we'll be taking live questions. So if our mentees still have questions that they would like to ask in class, please we would like to take your questions also. But let's getting straight to the questions on the chat box. The first one is how do we optimize patent application strategies in provisional filings?
So when you say patent application strategies in provisional filings, now I want to believe that from what I said, we now understand the difference between provisional and non-provisional. Because from the way you were presenting, you were talking about provisional as if that is your patent application. Provisional is not your patent application. It's just like your first submission. It is not the final. It's your first submission so that you can key in a particular date. And when your patent application has developed well, and when you are done with whatever it is you are doing, within 12 months, you are able to bring up your non-provisional application, which is your patent application that is going to be granted or rejected at the end of the day, and it's going to have your claim and everything. So once you bring your non-provisional application, the only thing you are going to do is you are going to claim the same dates of your provisional application. The provisional application doesn't go through any examination because it is not the patent application. So what I would say is the strategy you can use is in some other countries, they have something called utility patent. Now, I don't want us to mix this up because if you read through utility in the US, they use utility to describe kind of industrial applicability. That's how they describe theirs. But there's something called utility patent, which is also known as a smaller patent. A smaller patent doesn't require inventiveness as opposed to the normal non-provisional patent application. So if you feel like, yes, I have something new and it's industrially applicable, but it is not inventive, you go for utility patent application. And utility patent doesn't have 20 years protection period like patents. Utility patent has 7 to 10 years protection period, depending on the law of your jurisdiction. So let's now assume you filed a utility patent application and you've now developed your invention more. You can proceed to file a provisional. When you file provisional and you have feel like, okay, yes, I'm ready to file my non-provisional application within that 12 months, then you can now proceed to file your non-provisional application. But like I said, a provisional application is not your main patent application, just to be clear. I hope that answers the question.
All right, Smart. Thank you very much for that. The second question on the chat box is what are the specific regulations and procedures for filing patents locally?
Okay, so when you are filing patents locally is more like what we call the national application or regional application, depending on how many countries you are designating. So if you are filing your patent nationally, the first thing you have to do from scratch when you start to talk about patent, what is patent? Patentability. You want to have a patentable subject matter. You want to make sure that your invention is new. It has an inventive step. It's industrially applicable. You want to make sure that you've done your patent search and there's no prior act that is likely to invalidate your application. So you want to make sure that you've done your assignment before filing. Because if you don't do your assignment or you don't do your due diligence and you file, at the end of the day, your application will not be granted and it will be rejected. So you want to make sure you've done your findings. You make sure that, okay, yes, if I file this, I have maybe 80 to 90% probability that is going to scale. So when you file, you want to know, okay, how do I file? Who is filing for me? Which country am I filing in? What is the law of this country? Does this country has grace period? Also, what can I benefit from this country? So you want to understand all of these things when you are filing in the local patent office. How much do they do substantive examination, or do they do just formality examination? So these are the things you want to know when you are filing, so that at least at the end of the day, you can at least say that, yes, I think I've done a very good job and I expect my patent application to be granted. So I think that's what I would say for that aspect.
Okay, thank you again, Ma. Third question here is, what are the benefits and challenges for using regional patent filing systems?
So the benefits and the challenges, I would say when it comes to regional filing system is beneficial in some instance. For example, you want to file a patent application, let's say in Nigeria. Nigeria is not a member of the regional filing system. When we talk about regional filing system, we have ARIPO. The ARIPO, we have OAPI, we have EU IPO. So EU IPO is the European Union Intellectual Property Office. It's more for the European Union countries. ARIPO is the African Regional Intellectual Property Organization for English-speaking countries, while OAPI is African Regional Patent Application for French-speaking countries. So now, if you want to file your application in countries that speak French, you will not go through ARIPO. You will go through OAPI. If you want to file your patent application in the region that speaks English, you will go through ARIPO. If you want to file a patent application in the European Union, you won't go through ARIPO and you won't go through OAPI. You will go through EU IPO. Okay, and most of these, for example, OAPI runs a unitary system. EU IPO runs a unitary system, but ARIPO does not run a unitary system. Unitary system meaning that if I file a patent application in OAPI, it covers all countries in OAPI. Okay, if I file a patent application in the EU, it covers all the states in the EU. But if I file a patent application in ARIPO, it does not cover all the countries or all the states in ARIPO. You still have to designate the states you want, because each of these states have their own patent office. Unlike OAPI, OAPI just have one patent office that runs for all the states in OAPI. Okay, so the benefit is you want to file in 10 countries. Why do you have to go to Ghana, go to Togo, go to Senegal, go to this, go to that, when you can file just one application, designate the country you want, the state you want to designate, pay the fees and application when you look at the rules and regulation. Now, the downside, another benefit is that it's going to be cost effective. So I would say ease of use, efficiency, and economical. That's the benefit. Now, the downside, you don't really have much downside, because when it comes to patents, you don't need any requirements for basic mark as compared to trademark. So the only downside is that when you file through in fact, even when you file internationally, there is no guarantee that your designated country or designated state is going to grant. Nigeria can decide to grant. Ghana can decide not to grant. South Africa can decide to grant. Kenya can decide not to grant. So all of this decision is left to the national countries now, not the filing system. So that might be just one disadvantage. But even if you file nationally, it's still the same way. Each countries will decide to grant or not. The regional system doesn't say because you file through regional, it will be granted compulsory. It's not compulsory. Okay, it has to be based on the national office, because they still have to examine it, either as to formality or as to substantiveness. I know that the IP law is territorial in nature. The laws that might apply in Nigeria might not apply in Ghana. So each national office still have to check your application vis-a-vis their law and decide to grant or not to grant. I hope that explains your question.
All right, thank you very much, Ma. The final question here is, do international patent filing strategies differ between the PCT routes and direct country filings?
Okay, so just like I mentioned while I was speaking earlier, that you guys have gone to read, okay, but the understanding is not there because the international filing system is the PCT route. Okay, there's no difference between international filing and PCT. PCT is the international filing route. So just like we have the national route, that's when you're filing in each of these countries. When you file in Nigeria, you go to Ghana, you file, that's national filing. When you file regional filing, you want to file in countries like we have many countries, maybe like 17 states, like ARIPO, you have about 17 countries in ARIPO. OAPI, we have about 22 in ARIPO, we have about 17 in OAPI. That's regional. Then when it comes to international, that is where your PCT comes in, the Patent Cooperative Treaty. It has about 150, 152, 140 something member states. So now you now decide to designate which countries you want to file in. So if you want to file your application in just maybe let's say Canada and UK. No, let's say Canada and US. That's 2 countries. Which one, what do you think would be preferable for you? Should you go through the national route or the international route? If you ask me, I'll say through the national route because you are filing in just 2 countries. You can just do individual, one in Canada, one in the US. But if you want to file like maybe 10 applications, I would say go through the international route because you can designate each of these 10 countries. But if you are doing international routes for just 2 filings, it might cost you as compared to filing in just go to Canada, get an agent to file for you, and go to get an agent in the US to also file for you. So in summary, international filing route is the same thing as the PCT. So the PCT system is the international filing route. Does that explain your question?
I'm sure it does, Ma. Thank you so much for helping us run through those questions. Please, do we still have any live questions? If we don't, in the absence of any, I think it's safe and fair to call it a night.
Do we still have favor on the call?
Oh,
I said, do we still have favor on call?
yes, favor is on call.
Yes, I'm still here.
Okay, so favor, I hope you got my explanations.
Yes, it's clearer now, especially as to the issue of provisional application and the non-provisional application. It's clearer now.
That's fine.
All right, thank you, Ma. Thank you to our mentees that are here. It has been wonderful this time with you all. All right, thank you, Miss Shu, for being here with us right from week 1 down to week 5. You are truly, your presence and your mentorly invaluable. We cannot, like Zinatu has said, that the mentorship program has helped her research skills, and it has just generally been one. Um, we are all grateful to you for what you do for us. And we say a big thank you once again. And I
Daniel, before
come
you
to the
round up,
end
I would
of
like
today's
to
session.
speak about Favor's question as to the mentorship. Okay.
Okay, go ahead.
So I think I heard Favor mention that she thought it was probably a one-on-one mentorship program. But I know that there's an option for a one-on-one mentorship. I guess probably it hasn't started running, but there should be an option for mentorship, one-on-one mentorship very soon. However, I would say that you should not wait for one-on-one mentorship. You can learn all of these things yourself, self-tutor. Just make sure you apply to patent courses and make sure you are taking the courses, you are serious with it. You learn everything you need to learn. Okay, so don't wait till a particular mentor comes to take you because, like the IP aspect is kind of dicey. In fact, you'll be surprised that if you are really interested, you go far compared to probably the mentor that's going to come and mentor you. Because in Nigeria, patent is not that rosy aspect of IP, unlike copyright and trademark. So all I just want to say is you can actually self-mentor yourself apply for WIPO courses, learn as much as you can, take their exams. The exams are, I think, they are very comprehensive. In fact, when you take WIPO courses and you write the exams, you will understand all of these things better, because when you write your exam, the way you're going to break it down, they'll make sure that, yes, this person understands what she's writing. Okay, so I'll just say try to apply for WIPO courses and any other IP or courses on patent, and you'll be good. Then you can now back it up with mentorship. Okay.
Okay, thank you so much. I will check out the courses
All right.
and
You're welcome.
thank you.
You're welcome. So over to you, Dennis.
Thank you very much, Ma. And I say it's safe to fear that Ms. Shukura's advice doesn't just apply to Favor, but to everyone who wants to build themselves and develop themselves in this particular space and in this particular field. Do your research. Make sure you put yourself out there. Learn as much as you can. Take advantages. Take advantage rather of what we are doing. Make sure the articles that we send out for you to write, you're writing them, and you are doing your research to the best of your ability, and also taking on further forms of mentorship, and also self-development. I'm sure we will all it will all be beneficial in the long run. So thank you again, everyone. Good night, and enjoy the rest of your evening, everyone.